Hello everyone, and welcome to the next in our series of bite-sized employment law guides looking at issues arising out of the pandemic. Today we are starting to look at data protection considerations in the workplace during the time of COVID-19. Now, this is a very detailed and very wide-ranging topic. So during the next 10 minutes or so, we are just touching the surface and giving an overview of the types of issues to be thinking about at the moment. So Sara, would you like to kick us off with the topic of workplace testing, which I think is one of the major ones that is arising at the moment?
Yes, Emily, more than happy to do so. I think we both agree such an important area and something that employers, if they're not careful, can make quite a few mistakes in. So one thing employers are going to be looking at the moment is workplace testing. So there is a real balancing act that they have to strike here between the public health and safety interests, which are being widely publicised and well known, and being able to monitor individuals' health and the spread of the virus. And you can only do this by collecting personal information, but this has to be balanced by the individual's right to liberty and the protection of their personal data.
Yeah, and I think that's such a delicate balance. And thankfully, the ICO, so the Information Commissioner's Office, has issued now a wealth of guidance. So there's a dedicated section on the ICO's website called Data Protection and Coronavirus Information Hub. And so this should really be the first port of call for employers at the moment. Mm-hmm. And in particular, it has individual guides on, for example, testing, surveillance, and individual rights. So it's very helpful information, but with the caveat that it is quite high level at the same time.
Well, I think what's very interesting is the ICO have been so careful to try and say that data protection isn't an impediment to employers adopting sensible and reasonable measures to protect the health of their employees. We are in a pandemic. The ICO have obviously recognised that you have to give priority to that. But there are other factors, are there not, Emily?
Absolutely, Sara. So the guidance, very much, I agree, it seeks to facilitate testing and safety measures rather than making them difficult. But it's by no means an invitation to employers that they can lower their data protection standards. So that it's not quite as positive as it may seem, but there is going to be a certain amount of leeway, as we'll see in due course. So before we dive into the guidance, I think it might be worth looking at the legal framework when it comes to processing employee data. So where do we begin with that, Sara?
Well, the legal framework really is so important with this. So I think starting firstly, when adopting measures to detect, contain and prevent the spread of coronavirus, employers are going to be inevitably processing personal data of their employees. So this is lots of information they wouldn't normally be collecting or even seeking to collect. You're not just talking about the health status of your employees, you're probably looking at the health status of those they live with, who they may be coming into contact with, their COVID-19 test results, if they have had a test, and the location of places they visited. We've mentioned in a previous series that holidays may be back on the agenda, so you could be looking at all sorts of complicated criteria about whether there are flare-ups not just in this country, but in the countries your employees are visiting over the summer period.
Yeah, and as we know, when it comes to processing personal data, that obviously has to be done lawfully, and that's to say it's in accordance with the requirements of two key pieces of legislation. So firstly, we obviously have the GDPR, everyone's very familiar with that by now, and that applies in the UK during the transition period by virtue of Section 3 of the European Union Withdrawal Act 2019. And then secondly, we have the Data Protection Act 2018, which is the piece of legislation that implements the GDPR in the UK. So what do those pieces of legislation tell us about the processing of personal data and how that can be done lawfully, Sara?
So under those two pieces of legislation that you've just referred to, Emily, employers can only lawfully collect and process data about their employees where they have a legitimate interest. And I don't think that we can underline that enough. It has to be a legitimate interest under Article 8 of the GDPR, but it also has to satisfy a specific condition for processing special category data under Article 9 of the GDPR, and this has to be read together with paragraph 3 of the first schedule of the Data Protection Act. So there's a lot of detailed law, and I think we're just going to touch a little bit more on Article 6 and then Article 9. Is that right, Emily?
Absolutely, Sara. So just to really break it down into the essentials. So starting with Article 6, so this is the legitimate interest point. It's pretty clear that when it comes to processing personal data for health and safety purposes, so the type of data that we're going to see processed for COVID related purposes, employers are going to be relying on Article 6 1C of the GDPR, and that is compliance with a legal obligation. So it's quite clear that that covers the situation that we have with COVID. So because we do have, again, that special category element, what about Article 9? What are the conditions that employers are able to refer to in Article 9?
Well, we're looking specifically at Article 9(2)(b), and that's processing necessary to comply with employment law obligations. So we've got a raft of employment law obligations that existed before this pandemic. That's all the health and safety laws, but also the laws that have recently been enacted by the government, including regulations. And one would probably say that the guidance that the government has produced as well ought to be considered when you're looking at Article 9(2)(b).
Absolutely. So I think that's the most obvious one. And then it's just worth mentioning there is also Article 9(2)(i), which is processing for reasons of public interest in the area of public health. So that's also available in case. So I think the bottom line is, looking at the legislation, that employers can collect and process employees' health data relating to COVID-19, but they must be transparent. I think transparency is the key term. So they have to explain what they're doing, why they're doing it, and how long they intend to use the data for, and how long it's going to be retained for thereafter. So, Sara, there's also the requirement, isn't there, for a policy document in certain situations. Could you perhaps tell us a bit about that?
Well, it links very strongly with the points you've been making, Emily, about transparency. It's not enough as an employer that you know what you're doing. The employee needs to know, and policy documents are key to that. So you're going to have to put down how you're complying with health and safety obligations and justifying what data you're processing and to what extent you're processing it. So you must ensure you have the appropriate policy document in place, and it has to cover those matters you've talked about, retention and erasure policies.
Yeah, and it's also important to note that it has to be reviewed from time to time, so you can't just produce one and then that's that. Have to keep reviewing it and have to retain it for 6 months after the processing activities have ended. And then I think just finally, I'd mention a data protection impact assessment, which is something that the ICO is encouraging employers to have to ensure that their testing is appropriate and compliant. So usefully, there's a template available on the ICO website, which can act as a useful starting point. And that should set out the activity that's being proposed, the data protection risks associated with the activity, whether the activity is necessary and proportionate, and then mitigating actions, or what we might call safeguards. So that's an important consideration as well. I think that brings us to the end of this first part on data protection, and we'll be following up with a second video looking at the ICO guidance in a bit more detail.
Great. Thank you, Emily.
Thanks, Sara.